Now, many of the newly converted islanders were outraged, but King Kamehameha III was no dummy. He goes ahead and promulgates a new law in 1833 outlawing weapons for use by common people. So this is what the Hawaii Supreme Court is harping on. They're saying, oh, weapons are outlawed, but by the king, and it's aloha, and that's great because the king said that weapons are bad. But remember why he did it. He did it because he wanted to kill everybody off and make sure that he could concentrate power in his hands. So that's why we have a second. One of the reasons why we have a Second Amendment is to prevent exactly that. So you can see the Hawaii Supreme Court going along with the Leviathan, not the people. Okay, so what ended up happening is in 1848, King Mahele put through the Kaliana Act and stripped navies and land, stripped the natives of their land. So he passed the Kuleana Act in 1850, basically stripping the natives of their land, his subjects of their land, for cash. And the way he did that is because in Aloha, in the true Hawaiian, not the people, the original Hawaiians who looked like Samoans, their religion was, and their thought process was, there is no property. I just belong to my wife, whatever. They had polygamy. It was totally different. Like they didn't understand property rights the way the Europeans do. But the kings and queens adopted those European ideas in order to consolidate power. They even tried to do a allodial title. They basically, the kings and queens of Hawaii basically took whatever was favorable to them from European ideas and basically took advantage of the fact that their subjects were not educated in that area of law or that system. So what they did is the Mahele allocated 1/3 of the land to the moat, the monarch, and another third to the ali'i and konohiki, the chiefs and the managers, kind of like his loyal subjects, not even a parliament. I mean, these are like his courtiers, right? Okay. So now the remaining 1/3 was given to the maka ai na'ana, the uneducated, mostly illiterate common people. If they filed within 2 years, they actually had to file within 2 years. These people don't even know how to speak English. They don't know anything about common law, American common law, allodial title, any kind of title. They don't know any of this stuff. And so that was the Kuleana Act of 1850 when all this happened. So the Kuleana Act, the king basically gives the local people 2 years to be able to buy their own land because the king wanted to convert over to a more of a European style property rights system. So he was already taking advantage of the good things about English common law, but he wasn't making it instituted with his own people. He was sort of, he was taking advantage of it for himself to be able to buy, trade, and sell himself. So now this land, since it wasn't filed in 2 years, what ended up happening is few Hawaiians made a claim, and most of their land was sold by the king's government to large corporations and people like that, out-of-towners. So the state ended up with about 32% of the land, and 4.8 of the land percent-wise went to the Hawaiian homelands. Natives had no concept of property rights. So I'm trying to get you through this quick. So on January 17th, 1893, the Hawaiian kingdom was overthrown by U.S. Marines because they were there under the guise of protecting American interests after a coup was initiated against the Queen by a combination of locals and Westerners, people who had sort of taken up residence there. So she abdicated under duress to the United States, but the United States ended up annexing Hawaii in 1898. So that subjected it to the laws of any territory in the United States. All right, of their laws. But the Queen said something really interesting and telling about what the royals were really all about. She declared Hawaii to be her property in this handwritten letter, which I've included here. I wish I could make it bigger for you, but she did this handwritten letter where she said, taking a property without due process of law and without just or other compensation. So you can see that the king is relying on European-style laws, American common law laws, to get her property, which is Hawaii. It doesn't talk about her subjects, none of that stuff. She just wants her property back or wants to be compensated for it. That's really what this letter says if you read it through the eyes of someone who's not biased and brainwashed by a leviathanic educational system. Now, what ended up happening here is there's been this battle because of Hawaiians being a native people, at least the original Hawaiians. The people who are there now who say that they're natives were Filipinos and Japanese people that were there to do other work like cane fields and stuff like that. Now you're considered a haole and they're considered to be one of the original Hawaiians. And that's one of the problems with Hawaii is it has become really race oriented. And so the court has apparently ruled in this way. But what you'll see here, it really is more about the native traditions, and that's what I believe should be upheld. And so what it's saying here is that a reasonably exercised constitutionally protective Native Hawaiian right qualifies as a privilege when defending against criminal trespass charges. And that is a Native Hawaiian law training manual in 2022. So what the court is relying on is something a little bit different. The court is saying that, by the way, hunting and self-defense is a traditional right since 300 to 1400, before the royals took over and wanted to put down people from being able to fight against their unfair power. So that's what this is really about. So the Hawaiian norms and values from 300 to 1400 AD are in the Kanawai, and they enforce the social order. And you definitely have the right of self-defense. It was throughout their culture, Hawaiians were armed. They carried paddles with shark's teeth, whatever. All right, so here we go. But the Hawaiian Supreme Court argues that the law of the splintered paddle at 16 means that since it's a crime to attack women and children, like a real man wouldn't hit a woman or a child, but that really means that since a paddle was used, that paddles are illegal. That's basically their argument. It's one of the most poorly reasoned and historically inaccurate pieces of literature I've ever seen, a fiction that I've ever seen in my life. So now it used to be. So after this, after the king passed these laws that basically tried to make it hard for people to rebel against him, a law was passed that people could carry a gun for good cause. So that's 1896. That was sort of ignored by the courts. And they're basically saying, well, it would require a permit first. But when you look at the history behind the permitting process, it was really just that it was a way to generate fees. There was no test. There was no... It was a shell issue. You pay the money, you're going to get to be able to carry your gun concealed. That's all that was about. That was 1896, so you could carry a pistol or a firearm. So there is a history under the Bruin case to establish this. Now, and that's called Republic of Hawaii versus Clark. It's an 1897 Hawaiian Supreme Court case showing that if good cause could be shown and good cause could be self-defense. So that's the point I'm trying to make. It's very, very terrible what's happening to Wilson here. So now ultimately Hawaii is bound by the Bruin case, even though they want to argue this hodgepodge of a strange historical interpretation. But just remember, folks, their historical interpretation is based upon a powerful monarch issuing an edict to quell the ability of his people to fight back against his unfairness. So that is something you really need to think about. You have to understand that the Leviathan does not want you to have the means to resist. And so it appears as though Hawaii is trying to rule by Leviathan. Bruin set a new standard for interpreting gun laws that the courts now had to do what they always used to do, which is look at the history behind gun laws coming all the way back from ancient England. And clearly, in this country, we've always had a tradition of being able to be armed in public or private, as long as it doesn't present a dangerous or unusual scenario. Now, dangerous and unusual would mean like going through a shopping mall on a horse towing a cannon. That would be dangerous and unusual under the original common law understanding of what those terms meant, not what some modern court wants to create a new definition of something that never existed to then try and say it means something. And that's what these courts are doing, by the way. You have legislature giving definitions to the word for a centerfire rifle, calling it an assault rifle because it looks like one that's used in the military. So you have that. And what Bruin is saying is no, they have to be consistent with the nation's histories and traditions. Stay tuned.